So the Supreme Court just handed down a 9-0 unanimous decision this week, just a couple days ago, and it's a major win for advocacy groups, including those who fight for 2A rights. The Supreme Court just struck down a key tactic that's actually used by government agencies to try and intimidate these groups, collect their donor information, and really stall out some of these cases. This type of tactic has also been used in multiple 2A lawsuits against these various 2A groups. And now the Supreme Court has made it very clear that that alone is enough to show that constitutional rights are violated. This critical ruling ensures that 2A advocacy groups and their efforts are protected, and that our information by being members in these groups actually still remains protected. So let's break down what just happened in this critical case. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply to subscribe. About 60% of all viewers here on the channel are actually not subscribed, so that's a great way to support what we do here on the channel. Also, you can just hit the like button. That tells the algorithm that you appreciate this content, and so it shares it with more people. I also want to mention that we still have the giveaway going on, which is the night vision goggles, the white phosphorus, night vision goggles. If you want to enter that, you still have just a couple days. That giveaway is actually going to end on May 1st at 11:59 Pacific Standard Time. So you only have a little bit more time to get in. Tomorrow is actually going to be the last day to enter. You can get in by using the links down below. And again, good luck to everybody that enters. Now, as I mentioned in the intro, in this video, we're going to be discussing a very interesting 9-0 unanimous decision that was just issued by the Supreme Court this week. This case involves the First Amendment and protections for various advocacy groups. This case is called First Choice Women's Resources Centers versus Davenport. Now, this case involved a nonprofit being investigated by New Jersey's Attorney General, who issued subpoenas demanding that the donor information in this group, internal records, and fundraising activity be given over to the state. The group challenged those subpoenas in federal court, but the lower court ruled that the group did not have standing yet because they believed that the subpoena had not been actually enforced yet, and there were no penalties that had yet been issued against this group, and so they claimed that there was no harm to this organization. The group, however, challenged this all the way up to the Supreme Court, arguing that the mere threat and intimidation of demanding the disclosure of this type of information was enough to trigger constitutional violations. The Supreme Court granted review to this case, and on review this week, the Supreme Court issued a 9-0 unanimous decision, and they agreed with this group's position in this lawsuit. Justice Gorsuch, writing for the majority of the court, outlined that you do not have to wait for punishment to trigger this type of harm. If the government is already pressuring your rights, that is enough, and the court held that demanding the donor information or the member information can actually create an immediate constitutional injury because it's disclosure of speech and association, and again, that's enough to trigger this type of constitutional violation. The Supreme Court stated that the group had already changed how it operated, removed content, and also lost some donor confidence, and that was enough for them to actually bring this lawsuit. And here's where this court's reasoning really matters. Gorsuch explained that the harm is not just when the government acts. The harm is that there is a threat hanging over your head. And those alone kind of change behavior, that chills speech, and that creates a constitutional injury. And again, that is enough to bring a lawsuit. Now, this is not just an issue that is isolated to this one group in New Jersey. This also impacts groups in the Second Amendment space, and that is why various groups like Gun Owners of America filed amicus briefs in support of the petitioners here, saying that the Supreme Court needed to rule in their favor. And fortunately, that did happen with that 9-0 decision. And they argue that because we've seen a lot of this actually play out in the 2A space with 2A litigation. Government agencies and states often argue that these 2A advocacy groups don't have standing. They say that you're not directly being harmed, that you're not being prosecuted, and essentially they argue that you need to come back later when you prove something like standing or you give up this type of donor information. And that type of argument has been used in the past to delay or shut down these cases. This ruling cuts directly against that type of approach because now the Supreme Court is saying you do not have to wait. If the government action is already chilling your speech, deterring your members, or impacting your operations, that is enough to get into federal courts. And that is a major shift and win for groups like Gun Owners of America, FPC, NAGR, and others. And we're already seeing the positive reaction to this ruling from various 2A groups. For example, Gun Owners of America put out a statement on this ruling, and they said that the Supreme Court unanimously rules leftist AGs cannot intimidate nonprofits by demanding donor lists. Even the threat chills speech, and groups can fight back in federal court immediately. GOA was proud to weigh in with an amicus brief, and they stated that this is a major win for privacy of our members. Also, you had Senior Vice President of GOA, Eric Pratt, friend of the channel. He stated that privacy isn't a loophole, it's a safeguard. This was a huge win in court and should serve as a warning shot against future intimidation. GOA will keep showing up in court to defend these freedoms. So again, positive responses from 2A groups about this ruling. And again, this has significant implications for 2A cases going forward because in the past, we've also seen the government push to identify members in 2A cases. The perfect example of this is stuff like the FRT litigation. In those cases, those cases were settled with the government, but then the government pushed for lists of impacted members and people who are involved in these organizations. And we've also seen various state and federal agencies argue that these 2A cases, can't move forward, that these groups can't bring these cases, that they don't have standing if they're not willing to identify the members that are implicated. Those are attempts by the government to scare these groups and prevent people from wanting to join them and support their efforts, and now that has been shut down. And like I mentioned, this Supreme Court decision directly pushes back against that tactic that is used by government agencies in various states. The court is making it very clear that demanding donor or member information is itself a constitutional issue because it discourages participation and speech. So now groups have a much stronger argument that they can challenge these demands immediately if it ever happens again in these types of cases, including 2A litigation. So while this case isn't directly about gun rights or anything like that, it could have a major impact on how gun rights cases actually are fought going forward. This just gives an additional layer of protection for these groups when they file lawsuits against agencies like the ATF or the DOJ or various states when they pass certain laws. And that is why groups like GOA filed amicus briefs in support of the petitioner in this case. So that's the latest Supreme Court 9-0 unanimous ruling that was issued, and that's why it matters for Second Amendment, speech and 2A litigation going forward, and that's why 2A groups actually jumped in support of this litigation. So now we will see, if this ever pops up again in any of these 2A lawsuits. Like I said, this was one of those tactics that was used quite often in 2A lawsuits to try to stall the cases out or to get member information, but now that has essentially been shut down. So as we get more information, if this develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of content, and so it shares it with more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.